Hello, everyone. Eric's telling me to say hi. This is Mary Hart.
Tonight, whether you worked really hard just getting started, either way, you want to keep what you've earned, right? You want to keep what you've got. You want to be able to go to taking care of your family and your dynasty, not necessarily Uncle Sam. So, you want to be leaving that legacy and securing your family's future. It's pretty basic, family type thing. The thing is it took us a long time to captivate this expert. I heard her in Alaska, and I just couldn't wait to get her to Toledo. Correct? Everybody's nodding their head. She's a retired attorney for over 30 years, but she currently spends her time as an active real estate investor, a private lender, a national educator, a mentor, a tax-deferred exchanger, and more. She is going to tell you how to do the ultimate love letter. Let me introduce to you Mary Hart.
Hello, everyone. I see a little bit of a delay. I hope you can hear me okay.
Nod your head. Yes, we can. So please wait for microphones if you have questions.
Okay. Are you ready for me to share my screen?
Yes.
Okay. Let me see if I can get my PowerPoint presentation up here, and then we'll start. Let's see. All right. Let me start this slideshow. Hold on. This is always interesting to do. Okay. Can you guys see that slideshow okay?
Yes.
Okay. It's hard for me to hear you, so
Yes,
let
we
me
can.
just, what's that?
Yes, we can.
Okay.
Yes.
All right, great. Well, my name is Mary Hart, and as Anna said, I am licensed. I just don't practice as a lawyer. I practice as a consultant. So that means I don't have to keep my malpractice insurance up, and you can't sue me for failed legal advice because I'm not a lawyer anymore or not practicing as one. But anyway, this is a subject that I'm passionate about, and I call it writing your ultimate love letter. And it's not the romantic love letter and some of the financial organization that goes along with that. And what I have found over 30 some years is that there are a lot of concepts that are not really, they're not readily taught in our school system, or we don't talk about them around the dinner table. And so there are a lot of misperceptions about estate planning and wills and things like that. And so I'm hoping that this will get rid of some of those misperceptions if you happen to have them. And if you have not done your estate plan yet, I hope it serves as a catalyst to have you start getting ready for your estate plan or start preparing your estate plan. So let me tell you who I am. I just mentioned all that, so I'm not going to really go through it again. I am currently in mentoring and educating. I'm not, as I said, lawyering. I do some consulting on the side, but mostly I'm educating and mentoring and doing my own investing. This is my disclaimer. I heard Anna say one earlier, but obviously, although I am an attorney, I am not your attorney. So this is just education tonight and general information and not legal. Okay, what are we going to talk about today? I want to talk about what an estate plan is and why you probably need one. How do you plan if you become disabled? So it's not just for death. It's also what happens if you can't make your own decisions. How do assets pass at death? This is where I think there are a lot of misperceptions. And we're going to go in great detail to make sure that everybody understands the right documents to use to make your assets go where you want them to go when you die. We're going to talk a little bit about probate and avoiding or minimizing probate fees. We're going to talk about estate taxes, what they are, how they're calculated, what is included in your estate for estate tax, and we're going to touch briefly on the fact that the estate tax exemption is dropping drastically in 2026. That's the last thing, the sunsetting of the exemption amount. Okay, so for me, estate planning, besides just being, somewhat tedious and having to prepare documents and maybe meeting with lawyers, but it's really about you being able to take control of what will happen if you're either disabled and cannot make your own decisions, or if you die, when you die. It's not an if, is it? It's a when. I also think that estate planning and legacy starts in life. It's not just planning for disability and death. It's also how you lead your life and the role model you are for other people, for your kids, your community. But that's a topic for another day. Right now, we're just going to talk about the traditional estate planning documents. So estate planning we use to accomplish family goals, to protect your loved ones, to safeguard your wealth, and to leave a legacy, among other things. I have seen in my 30-some years, a lot of you have arisen when people don't have an estate plan, or it's not updated, or it's not done properly. And it really causes a tremendous amount of stress to your family when you don't have your estate plan done, or it's not updated or done correctly. Family fights among themselves sometimes, or they end up paying a lot more in fees, costs, and taxes than have to if things were planned properly. We see a lot of high probate costs when it's not necessary, a lot of attorney's fees that might not be necessary. And we see family members who aren't legally related, maybe stepchildren, life partners that aren't married, things like that, being left out because they're not in the estate plan that the state has created for you if you don't do your own estate plan. So those are some of the high costs of not doing your estate plan. And I know it's not fun to do them. It's a little bit tedious. It costs some money. A lot of people don't do it because they're not exactly sure what to do. They don't know where to begin. They don't know what lawyer to hire. They don't have the money to do it. They don't want to take the time out of their busy lives to do it. And they don't really understand the consequences of not doing it because they've never been put in that situation where they've had to deal with an estate that did not have a plan. So I do have some homework for you. And if you have not already done your estate plan, my encouragement to you homework is that you do set up an appointment with an attorney and try to get your estate plan done in 2024. That's the first thing, is set up the appointment. And these next things, you'll see why they become important. But I want you to make a list of all your assets and how they are titled. And you'll hear more about that as we go through this presentation. And think about what your goals are. You know, who do you want to leave things to when you're no longer here? How do you want them to receive them? Outright, in a trust? Can they manage these assets themselves? Do they need help? If you have particularly difficult to manage assets that need specialized skill, how are those going to be dealt with? If you have children who are not in your business, but you want to leave them your business, how is that going to be handled? So this is your homework I'd like you to leave here with tonight, is thinking about this if you have not already done your estate plan or thought about these things. I call this your ultimate love letter. This is a picture actually of the copy that I have printed out and stuck in the front of a giant 3-ring binder that I'm working on for myself, where it's going to have every single bit of information my loved ones are going to need if I can't be here to help them, if I'm either disabled or deceased. So everything from the list of my assets and how they are owned, to the deeds to the properties, to the copies of all the estate planning documents, lists of bills are paid, what's on auto pay, what's not on auto pay, what accounts is it paid out of, all my personal information, all my family's information. You can imagine how much information your loved ones are going to need if you're not there to tell them that information, particularly if, as the real estate investor, you are the one running that business in your family. Some people, their spouses or children run it with them. Other times they're a lone wolf like I am. My husband is not involved in the investing side. He has no idea how the bills get paid or anything else. And so it is up to me to make sure that if I die before him or become disabled, he has that information to move forward with without a lot of stress. Okay, this is what I was just talking about, that notebook. I'm not going to go through this in great detail, but anything you can think of that you have to deal with, or the information that you need to run your life every day, from the moment you put your feet on the floor in the morning, until you go to bed, all that information that's in your head needs to be in your letter notebook. Okay, so what does an estate plan do for you? You guys probably know this, but I'm going to go through it real quick. Not only does it allow you to set up documents to help take care of yourself, like who makes your decisions, what types of decisions you would want made for you if you're disabled, but it also helps the people you love. Take care. It minimizes the hardships of growing older. I'm not going to read the whole list outright. You have it in front of you, but just think about how hard you've worked to grow this wealth, to build your business. And let's make sure that everything you've worked so hard for gets passed on to your family in a way that is the least stressful, the least costly, and the least likely to result in family infighting and problems between your loved ones. Okay. Most of the time, an estate plan might sound daunting, but it really probably takes less than 20 hours of your time. It probably takes less than that, actually. But really, only 67% of Americans have an estate plan. And that means 67% don't have an estate plan. I apologize for that. That's backwards. Only a third of us have an estate plan. 67% of us don't. If you're a real estate investor, that estate plan, in my mind, becomes even more important because you have a diversity of asset classes that's not always liquid. If it's, say, rental homes, commercial buildings, promissory notes, you need someone who's knowledgeable in managing those assets or liquidating them in a reasonable fashion. And there are sometimes difficulties that can arise if you own those assets with other people or in businesses that are co-owned with other people. So I think for us real estate investors, this becomes even more important than someone that's, say, has all of their assets in cash and stocks and maybe one primary residence. Those are much easier to deal with than the types of assets that we have on our balance sheet. All right, so we talked about that. I've always thought that once you get this done, it's no fun, but once you get it done, you might have to tweak it every year or so, but you can just go about the business of living knowing you've done everything you can to protect yourself, your family, the causes you care about. And that's why I call it your ultimate love letter, because it is truly the nicest gift you can give your family. And if you're thinking about taking the kids and grandkids on, say, an expensive cruise or something like that, and you have not done your estate plan, I encourage you to give them the gift of your estate plan first, and then next year. Okay. Let's talk about estate planning objectives. And I should say that we should have time at the end of this to answer your questions. So write down your questions as we go, and then I'll be happy to stay and answer questions as long as you want me to. So when we're doing an estate plan, we're trying to accomplish a number of objectives. You obviously want to accomplish your family goals, your personal goals. We want to try to avoid probate and the high costs associated with that and the tediousness associated with that. We definitely want to avoid or minimize estate taxes and income taxes. We want to plan for our disability. We want to leave a legacy. That's how people remember us. We're no longer here. So those are the things that I think of when we're trying to set up an estate plan for someone. And the first thing we do when we're setting up documents is look at the documents that you would need if you became disabled and could not make your own decisions. And I think every person over 18 and over, whatever the age of majority is, should have these 5 documents, or at least the first 4. And we're going to go through each one, but they're your healthcare power of attorney, your durable power of attorney, a living will. That's what we very crudely call the pull the plug document if you have an irreversible or terminal condition, a HIPAA waiver, and potentially a hospital visit authorization form. We're going to go through all these. So the healthcare power of attorney is a document that allows you to name one or more people to make your healthcare decisions if you are unable to make them yourself. So you can name one person with alternates to kick in if that person cannot act, or you can name people to act at the same time. We call those co-agents. If you name more than one person at the same time, we have to indicate whether they all have to agree or whether any one of those people can make the decision. For instance, my mom had a healthcare power of attorney where she named me and my 2 siblings because she never knew if something was going to happen to her when she was visiting one of us, and we all lived in different states. And so she made it that any one of us could make her decision. It did not require all 3 of us. But if you really want to make sure that everybody participates, you can make it so they have to have a unanimous decision. The problem with that, of course, is what happens if it's an odd number, or an even number, and you can't get an agreement. So I would caution you about that unless you have an odd number of people and it's majority vote. All right, the durable power of attorney is the power of attorney for everything but your health care. And that word durable is very, very important because it used to be, before the durable power of attorney was created by legislatures, that if I gave, let's say I gave Anna my power of attorney, act on my behalf, and then I became disabled or incompetent. The moment I became incompetent, that power of attorney was revoked by operation of law. It went away. It was no longer valid. Well, that's really when I need someone to be able to use my power of attorney, right? We don't want it to go away if I become disabled. So this durable power of attorney, in one sentence, that says something like, this power of attorney shall remain effective in the event of my subsequent disability. It's very, very important language. This power of attorney shall remain effective in the event of my subsequent disability. Without that type of language, if you become disabled, that power of attorney will be invalid under operation. So if you're going to do these documents on LegalZoom or through a stationery store, the old school way, make sure you pick the document that has that sentence in it. And I want to tell you a little war story so you know how important this is. When I was a new baby attorney, I was practicing in Alaska in the 1990s. I graduated from law school in 1991. It's not that long ago, but it was over 30 years ago, 33 years ago. Anyway, I was a new lawyer and I had a woman who lived in Ketchikan, Alaska, and she set up an appointment to come to Juneau and meet with me to get a deed for an apartment building in Ketchikan. Her name was Annie. She showed up and she explained to me her circumstances, that she and her husband owned an apartment complex. Her husband was quite a bit older than she, and he was in the Alzheimer's wing of the hospital at a cost of $12,000 a month in 1991. Can you imagine? So expensive. And they were selling that apartment building to pay for his care. Now, he was incapacitated. He was completely, mental competency at all at that point. And she handed me her power of attorney from him that said, she could do his real estate transactions, and so she could sign on his behalf. However, that power of attorney they did from a stationery store, and it was not a durable power of attorney. So it did not have that sentence that kept it effective once he became disabled. So as soon as he became mentally incompetent, that power of attorney ceased to be effective. It was no longer valid. So she had a closing scheduled on that apartment building that next week. And instead of doing the deed so she could have her closing, she had to file a guardianship for her husband to get the power to act for him. It's a lawsuit. So that was a big, big lawsuit. One of the people she had to notify was his daughter. That was not her daughter. And they had been estranged from that daughter for over 40 years. And so this woman, Annie, was petrified that this daughter was going to come in and cause a problem. Anyway, long story short, we eventually got her appointed as a guardian, but it took almost 2 years. Lost that apartment sale. I don't know how she paid the bills in the meantime, but all of that and many thousands of dollars of legal fees, all because that power of attorney was missing that one sentence that made it durable. So if you take nothing else out of this presentation, please remember to check your powers of attorney for that sentence. You don't need to worry about that in healthcare power. It is never effective unless you cannot make your own decisions. So it's only in this durable power of attorney that we want that sentence, because you can have this power of attorney effective the moment you sign it and have it remain effective if you become disabled, or it's a sleeping document and it does not even spring to life until you are determined to be in an affidavit of your physician. All right. The next document I mentioned was the living will, which is that pull the plug document. This is the document that basically sets forth your wishes that you would not want to be kept alive artificially if that is the only thing keeping you alive. So if you have an irreversible terminal condition that would otherwise cause your death in a relatively short period of time, this is the document that your healthcare agent can use to ask the hospital to terminate life support once the doctors have determined that you have no reasonable medical likelihood of recovering. And that's to a reasonable degree of certainty. Very, very important document. I did feel nervous that if they signed this type of document, that it meant the hospital was going to just pull the plug willy-nilly. And in my experience, that is not the case. The hospital is not motivated to terminate life support. One, they're making a lot of money off that patient every day they're in the hospital. And two, they don't want to get sued by family members who say the life support was terminated early. So rather than being permission for the hospital to pull the plug, I see this more as the sword that your family members can use to ask the hospital to terminate life support if there's no chance of recovery. Okay, the HIPAA waiver. You guys see these privacy notices when you go to the doctor's office. That comes from the Health Insurance Accountability Act. That's what HIPAA stands for. And we worry that your healthcare agents will not be able to get your medical information so they can make an informed decision because of those privacy rights. So we usually authorize your healthcare agents and anybody else you want, but at a minimum, your healthcare agents, we waive that privacy right and authorize them to receive medical information so they can make informed decisions for you. And then if you have someone who's not your legal family that you would want to come visit you in the hospital, if you are unable to make your own decisions about that, you can sign this type of document. It's a hospital visit authorization form that allows you to specify who's allowed in the hospital. And in fact, you can say who can't visit you in the hospital. If you have an estranged spouse or in-laws that you don't like or anything else, you can actually prevent them from coming to see you when you're in a situation where you cannot make that decision for yourself. So that's can be a very important document. For instance, when I was engaged to my husband, but we were not yet married, I did a hospital visit authorization form, making sure that he could get in to see me and his children. We are a blended family. Okay, who gets copies of all these advanced directives, what we call these? You're saying in advance what happens if you become disabled. Obviously, it's a personal choice who gets your copies, but you certainly should include your medical professional and people who are going to be making your decisions. They either should have copies or at least know where to get to the documents if necessary. In terms of where you store them, this is always a question because we want to make sure that somebody can find them and has access to these documents if you need them. If you're going to store them in your home, make sure they're fireproof, safe, because you don't want them to burn up in a house fire. There are some states that have online registries, like North Carolina has one, where you can file these documents with the state. And in North Carolina, they issue you a little ID card that you can keep in your wallet. And so should the doctor or your healthcare agent need the information, it gives the number of where to call that Secretary of State to get copies of the documents. We worry about putting them in safety deposit boxes because a lot of times people can't get in those boxes without a court order. And sometimes they can't get the court order until they get in the box to prove that they are the attorney, in fact, the agent. So that's a little bit of a dangerous catch-22. All right, let's move on to death. And I know we're going fast because there's just so much information. When I spoke on the RIA cruise, it was about 3 or 4 hours and I still didn't get through everything. I've done these classes for 2 days solid. So I'm trying to go quickly. And so we have time for questions at the end. All right. So when we're planning for death, it's a lot of control. We want to make sure that we die with dignity, with our wishes being upheld. We want to make sure that the people we want to inherit are the ones that inherit, and in the manner in which we want them to inherit, outright, in trust, things like that. We usually want to reduce the costs, fees, and taxes as much as possible. And those that are not liquid, like your rental properties, we want to make sure that they are sold properly, that they're not sold at fire sale prices, or that they're passed on to heirs who know how to manage them or want to manage them. So these are all some of the main concerns we deal with when we're doing an estate plan. The most important thing I think that people get wrong, because again, we're not taught this stuff, the foundation of all of this is you have to understand the way in which an asset passes at death. And most people don't understand that because nobody teaches us that. It's not necessarily intuitive. And once you know how an asset passes at death, we can determine document is the document to make it pass the way you want it to at the time of your death, and what you do to change that if you change your mind about how you want that to pass. Okay, so this is a chart, and we're gonna touch on this chart a couple of times. And you guys, if you haven't already, you should take a picture of this slide. Take a picture. This is part of the homework. The homework that I would like you to do is to write that list of assets, and next to every asset, I want you to write how it is titled, and we're going to go through this chart, And based on this chart, what document is the one that would pass that pass that asset upon your death? So if the asset is titled in your separate name, like let's say my deed reads Mary Hart, and that's it, just my name. That is considered a probate asset. It's going to pass to my heirs or devisees, and I'll explain that term in a minute, through my last will and testament, if I have one, or if I don't have one, through basically the legislative will that my state legislature has created for me. In every state default provision of who inherits the assets in your separate name if you did not prepare a will, sign a will. So the devisees are the people you've listed in your will if you have one. Your heirs or heirs at law are the people that are in name assets, your probate assets, don't have will. So that's why I say heirs or devisees. But this is only things in your separate name. So if something is in a joint name with the right of survivorship, that's the next one on the chart. Let's take my house. Let's say now it reads Mary and Frank Hart, husband and wife. That's joint with a right of survivorship. It's going to pass, if I die, to my surviving owner, to my husband. Even if I said in my will that Anna's going to inherit my half of the property, it's not going to go to her because it's not in my separate name. It's in my name with a joint owner with a right of survivorship. And the moment I take my last breath, that surviving joint owner is going to own the whole piece of property by operation of law and according to the deed. So I want you to look at the next one because this trips people up sometimes. Let's say that Frank and I both have our names on that deed, but now it says as tenants in common. And you guys, I'm sure all know what that is. But if it says tenants in common, it is treated as if each of our parcels is in our separate names. So let's say it was equal ownership, Mary and Frank Hart as tenants in common. My 50% would be treated as my separate property and passed through my will. And Frank's 50% would be treated as his separate property and passed through his will. So you can see that it's very important to look at the language in the title and the deed in this example. Does it read joint with the right of survivorship? Does it read tenants in common? It's a difference in how it passes at death. Now, let's say it has, Mary and Frank, husband and wife, and does it say tenants in common or with a right of survivorship? That's when you have to know your state law. So, for instance, in North Carolina, husband and wife who buy property together own it automatically as something called tenants by the entirety, which is a form of joint ownership available only to husbands and wives, and it passes to the surviving joint owner. So the deed might not say joint with the right of survivorship on its face, but state law makes that happen if you're a husband and wife in North Carolina. So you would need to know the state law in your state if you have more than one name on the deed, and it does not say whether it's tenants in common or joint with the right of survivorship. If they're non-married people and it's got multiple names, if it does not say right of survivorship, then usually that is tenants in common. So again, a right of survivorship to the survivor or survivors, tenants in common, your part is going to go through your will. Okay. If an asset is owned in the name of a trust or in the name of the trustee of the trust, it's going to pass to the trust beneficiaries per the terms of the trust. So just like a joint owner situation, if house is in the name of the Mary Hart Trust, and that trust says it passes to my children at death, if I take my will and say my house goes to Anna, it's not going to go to Anna because it's not governed by my will. It's governed by my trust, right? Because it's owned by my trust. So somebody's got to look at the terms of my trust to see who inherits the house. Now, let's say I have an asset that's in my separate name, but it has a beneficiary designation, like a life insurance policy or an IRA. That asset is going to pass the moment I take my last breath to the designated beneficiary, the person or persons that I have named on my beneficiary form. This may also be pay on death bank account or pay on death stock account, brokerage account, things like that. So even though it might only have my separate name on the statement, somebody has to know whether that is a pay on death type of asset. Did I ever name a beneficiary to receive that asset on death? If so, it's not going to pass through my will, it will pass according to that beneficiary designation form. Now let's talk about a life estate in a deed. So back to my house, let's say that I owned that house in my separate name, but I did a new deed that says to Mary I say I'm going to reserve a life estate, and then Frank gets it when I life estate. Mary and Frank, I reserve a life estate. He gets it when I die. In that case, my life interest is extinguished at death. So I have the right to live there during my life. I'm responsible for all the bills, but once I die, it passes to the remainder interest holder, when in my example is my husband. So that's the last name or interest holder when there's a life estate deed. So you can see why it's very, very important to understand how your assets are titled. And what I have found over the years is people don't remember how they're titled. Sometimes they don't even know. You might go to the bank and set up a joint account and not get asked the question by the bank person. They might ask, do you want this with or without a right of survivorship? And they might check without survivorship, and you might think it's with survivorship. So you need to look at the actual titling document, the deeds for real property, the signature cards for your bank account or your brokerage account, things like that. Make sure you know how things pass at death, because it's the only plan that really is effectuated the way you want it to be when you die. So again, the first thing you want to know is how your assets are titled in your name. If there's a joint owner, with or without a right of survivorship, is it in a trust? Does it have a pay on death beneficiary? So on and so on. Then you have to know the right documents. And we just went. So this is that chart again. If you didn't get the picture the first time, grab a quick picture. I take a sip of my tea. Okay. Let's talk about the word estate, because this is something I find that people don't understand, that the word estate can have different meanings depending on what's in front of it. So the term gross estate is a federal IRS term, really, and it means everything you have an ownership interest in, whether it's 1% or 100% or somewhere in between. It is what the IRS uses to determine whether you have an estate that is subject to estate taxes. That's your gross estate. So picture a giant circle on a whiteboard, and everything you have an ownership interest in is inside that circle. That's in your gross estate. Now picture a smaller circle inside the big circle. You can draw this on your paper if you want to. That might be your probate estate. And again, those are only assets that you own in your separate name. There's no designated beneficiary, not in a trust. There's no joint owner with a right of survivorship. So it's either just your name or your name as a tenant in common. That's your probate estate, and that's the smaller subset of your gross estate. And I just wanted to point that out because it makes a difference depending on what we're talking about. All right. Let's talk about the will. And remember, it only covers those probate assets, the things in your individual name. And obviously, you guys all know this, but a will provides for the distribution of that property, your separate name property that's owned by you at the time of your death. And you can pass it in any way you want, outright, in a trust, to more than one person, just one person. You can do what you want. Just remember, it's only going to cover those things in your separate name, no beneficiary, no joint owner with the right of survivorship, no trust. When we're using wills, it's not just passing assets on. We can also use wills to do all these other things. You might want to designate a guardian if you have minor children and you're worried that your spouse might also be deceased. You want to name an executor. We usually call that a personal representative now. If you have a will where you designate your executor, you waive the bond requirement. Usually we don't have to, your executor does not have to post a bond. If you do not have a will, in most, if not all states, your executor is someone who will then apply to be appointed. And there's usually a hierarchy set up by the state of who has the right to administer your probate estate. But that executor will have to post a bond out of their own pocket, like a bail bond almost, to make sure they don't abscond with your estate assets. So when we do a will and we're naming someone that we trust, we usually waive bond requirement. Okay, we can create trusts for either minors or disabled beneficiaries, people who maybe qualify for government benefits. Sorry, I'm about to sneeze, I have allergies today. We can provide for charities, we can accomplish tax savings, and we can provide for our pets. So there are a lot of things we can do in wills. We can do a lot of these in trusts as well. It's for more than just passing your assets. All right. What does it not do? Oops. Excuse me. Knew I was going to sneeze. All right. What does it not do? It doesn't govern those assets we talked about that don't pass through the will, right? Joint ownership, assets held in a trust, pay on death, things like that. All right, we got tenant in common, but I just wanted to highlight this on a bright white slide. Please check your deeds if something is, if you have a joint owner on a piece of property, make sure you know whether it is tenants in common or with the right of survivorship. All right, we mentioned this, I mentioned this a few minutes ago. What happens if you die without? We call that dying intestate. And if you die without a will, your state legislature has basically created a will for you. It is called the Laws of Descent and Distribution, and it will determine who receives your property by default. Usually it starts with your spouse or children and then goes to other family members, depending on who survives you. I think it's important for people to realize that in many, if not all states, your spouse does not automatically inherit 100% of an asset in your separate name when you die. Usually, it depends on who else survives you. If you have children from a prior marriage, for instance, your spouse will inherit some, your children will inherit. If you have children together, the percentages might change, but oftentimes it's still that the spouse doesn't get the whole thing. So you need to make sure that you either do your own will to say exactly what you want to have happen, or that you at least check your state's default will, the laws of descent and distribution, to make sure you like what they say if you don't want a will. Okay. This is what will happen if you die without a will. Things that will not happen if you die without a will. So things you might want to address in a will. Or revocable living trust. That RLT at the top of the slide stands for revocable living trust. We can do these things through a trust as well. But if you like the legislative will that the state has created for you, you want to alter that, then you would need to do that through your own estate plan. So if you want to change the shares that pass to your spouse or your kids or your stepkids, you want to leave something to your parents, you want to leave something to charity, you want to leave something to non-married partners, you want to leave some assets out, assets in trust or all in trust. That legislative will does not leave assets in trust. So you might have a 4-year-old child that inherits assets and someone will have to be their guardian until they're 18 or whatever the age of majority is. So we can use a will or a revocable living trust to change all of that, to change the legislative will to make it more suitable to our personal purposes. I see this top bullet point a lot in the real estate investing business. A lot of times we have one child who's active in the business and one or more children who are not. And a lot of times my clients were trying to figure out, well, how do I leave the business to the child who is in the business and still take care of my other children? What's happened? What's fair? And that can all be handled in a will or a revocable living trust. We also use these estate planning documents if you want to give specific items of personal property to specific people, like grandma's ring to your granddaughter Susie, or the gun collection to your nephew, or whatever it is. We can do that through your estate planning documents. If you have minor children, we can select guardians for those minor children in case you and their other parent both are deceased before they're grown up. And we can do things that will prevent us putting other family members in bad tax situations. What do I mean by that? So a couple things happen. One, sometimes you have someone who is in a bad creditor situation, and if they inherit money, it's just all going to go to their creditor. You might choose to have it done a different way than leaving it outright, for instance. You might think to yourself, well, I'm just going to leave it all to my oldest child, and he or she will distribute it to the siblings. Well, in some cases, causing a bad gift or estate tax problem for that child. So we might want to use a will or a revocable trust to set up exactly what we want without putting that child in a bad situation. So there are a number of reasons why it might be better not to just rely on that state legislative will. We can also put trusts in our documents for tax planning or non-tax planning reasons. So say, for instance, your kids don't get it at age 18. We can name a trust as the beneficiary of retirement benefits, but I will tell you that is not a do-it-yourself thing. You want to make sure and talk to an advisor before you do that, particularly after this new Secure Act that changed the stretch out where we have to the benefits to most beneficiaries in 10 years, other than a spouse and a few other beneficiaries. So we only want to name our trust as the beneficiary of retirement plans if there's a really good reason to do that now. Okay, we can use it for estate tax planning. We can have trusts for charities or just outright gifts to charities. A tip trust we see a lot in blended family situations where maybe we want to leave assets in a trust for a surviving spouse to make sure he or she is supported during their lifetime, but we want to make sure they cannot change the ultimate beneficiaries of that trust before they die. So in my situation, for instance, I'm in a blended family, 3 children from a prior marriage. My husband has 3 children from a prior marriage. So maybe we want to leave our assets to each other in a trust, so we make sure we're supported. But let's say I die first, I leave it in a trust for my husband. When he dies, it goes the way I have set it. So to my 3 kids for my assets, and his might be for his assets, because we didn't get married till we were in our 50s. So we both came to the table with our own estate, right? So we might want to use that particular type of trust to do that. Maybe we have a family member that qualifies for government benefits because of a disability. And if they inherited assets outright, it might disqualify them from the benefits. So we might use a supplemental needs trust to leave a fund to provide for things that the government benefits don't pay for in a way that does not disqualify that person from those government benefits. And that dynasty trust at the end is if we want to leave it in trust for multiple generations, usually so that it controls it and someone can manage it, but so that it avoids estate taxes at multiple generations. All right, this is something I just want to point out. I don't know that everybody realizes that if you're married, you cannot disinherit your spouse. A spouse has what's called an elective share. It's often about 1/3 estate that the spouse has a right to take and inherit, even if you say otherwise. So the only way you can disinherit a spouse is if you have a prenuptial agreement or a postnuptial agreement that allows that. Okay, so how do you ensure that the people you want to inherit get it, right? Well, we talked about this ad nauseum. You have to know how the asset is titled so that you know how it passes at death and what document is the right one to use. For instance, if I have a deed that passes automatically to a joint owner, the only way I can change that and keep it from going to the joint owner, if that joint owner and I sign a new deed, right? Because I can't do anything on my own to change that because it was set up that way when we bought the property. So if Frank and I, my husband, own a piece of property as joint with a right of survivorship, I can't put in my will that that property goes somewhere else. The only thing I could do is say, hey, Frank, maybe we want to change this to tenants in common so that my 50% can go to my children and your 50% can go to your children, right? So you have to understand the document that triggers how those assets pass at death, so you know if you can just change that document or if you need the consent of someone else to change the strategy. And if you're using a revocable living trust, which if we have time, we're going to talk about more, you want to make sure not just to draft this beautiful trust document, but to actually fund the trust by retitling your assets in the name of the trust. I can't tell you how many beautiful 80-page documents in red faux leather binders came into my office from other attorneys, beautiful tree paid thousands and thousands of dollars for. One spouse died, the other spouse came in to have me administer this beautiful trust, only to find out that no assets were ever put in it. So you don't want to make that mistake if you use a revocable living trust. Okay, let's move on to that. What do we do beyond the simple will? Let's say that we do something more than just a simple will. When we're looking at these, a more advanced estate plan, really in any estate plan, we talked about these multiple goals. Obviously, we have our personal and family goals, reducing taxes, reducing stress, and asset protection, income tax planning, things like that. We've talked about that already. I'm not going to believe that. What I want to point out, people ask me, what should I do about X, Y, and Z? And what I tell them is classic lawyer answer, it depends, because there is a continuum and everybody's going to fall in a different place on that spectrum, right? There are some clients who want to spend the least amount of money, don't care whether it's super effective, they don't want tediousness, they don't want to manage anything. And so they're going to get less, they're going to spend less, but they're probably going to get less protection. Where then there are clients on the far end who don't care how much it costs, don't care how tedious it is or how much it is to manage. They just want the most effective plan. Where you are on that line is a very personal decision. So there is no one state plan that fits every single person. And why do I say this? Because, in fact, I just ran into this again this past weekend. There are a lot of companies out there, I call them the trust mills, that they talk you into giving them a whole heck of a lot of money to do your plan, and they tend to spit out the exact same documents for every single client, regardless of what they're not. So be on the lookout for that and try not to fall prey to one of these mills that just pump out the same documents for everybody. And I'm not going to give any names, but you could probably figure it out. All right, let's move on to trust. And I know you guys are probably writing down questions. I hope you are, because we're moving fast and I want to be able to answer your questions at the end. So trust 101, I find that people get kind of confused about this. Maybe not this crowd, but some people do. So what the heck is a trust? You guys will figure this out. It's just a contract. That's all it is. A trust is a contract with various parties. And those parties to the contract are the grantor. That's the person who sets up the trust. Sometimes called the trustor or the settlor. They set it up. They usually put the money in it. There's the trustee. That's the person who's designated to administer the trust, to manage it and distribute it according to its terms. And there's the beneficiary. That they're not usually a signing party to the trust, but they are a beneficiary of the trust. They're like a third party. They don't have to sign the trust document. So again, just a contract. Every state allows contracts, so every state allows trusts. How do you create a trust? You really need a written document, and it is signed by the grantor 100% of the time. It should be signed by the trustee because the trustee is agreeing to take on certain tasks. It does not have to. I like to have the notarized if there's any reason you would ever want to record the entire trust document. Now, most people don't want to have their entire trust document recorded and made public knowledge because it's got a lot of information in there. That's when we see, like you probably have seen it in closings, a trust certification, a trust acknowledgement, different titles, but it's basically a summary of the trust that says who set it up, who's the trustee, what the powers are of the trustee, and things like that. That should be notarized because a lot of times that needs to be recorded for a closing, and you need to have those documents that are being recorded notarized, or at least in North Carolina where I record on. So in terms of types of trust, you'll see we've got two types. You can do inter vivos, that means during life. So you can create a trust during your lifetime, or testamentary, a trust to take effect upon your death. During your lifetime, these trusts can be set up to be revocable, changeable, and amendable, or irrevocable, unchangeable, not amendable. You can choose, and there are different reasons to choose different types of trust depending on what we're doing. So we just went through these definitions, but I'm going to tell you the last one I didn't tell you about yet. It's called trust protector. We usually see those in irrevocable trusts, ones that we cannot change without a court order after we set them up. And so a lot of times we'll put this trust protector in the document. They're not a trustee, so they don't have fiduciary duties, but we give them certain powers. Like we might give them the power to remove and replace a trustee. We might give them the power to stop a distribution to a beneficiary if we think they're on drugs or something like that. So this is a really optional role in your trust document, but it can provide some flexibility to have this trust protector. All right. We use trusts. There are so many trusts for so many different purposes. You guys might have seen all the acronyms out there, the SLATs, the GRATs, the CRUTs, the CRATs, the ILETs, the CRTs. so many. But anyway, using them for purposes like avoiding probate, creating privacy, lowering estate taxes, planning for a disability, managing assets for minors or other people who don't manage money well, for charity, for asset protection, to keep life insurance from being subject to estate taxes, to plan families, things like that. There are more reasons than we could go through. It would literally take me probably 2 days to go through all the types of trusts that you could have in your estate plan. So we talked a little bit about this. You create it with a written document, and you have to fund the trust if you're putting assets in it by changing the titling document to the trustee of that trust. So trust itself is an inanimate object, so it cannot be an owner per se. The trustee is the owner on behalf of the trust. So let's say I had a revocable trust called the Mary Hart Trust. My deed might read the Mary Hart Trust, comma, Mary Hart trustee, or Mary Hart trustee of the Mary Hart Trust. The way some, a lot of times people want to put the trustee's name at the end of the trust name because they're hoping that when the document gets recorded, that trustee name falls off and isn't immediately viewable in when people are searching the deeds. So we want to create the trust, we want to fund the trust, then the trustee manages and distributes the trust assets, what's written in the trust document. In some cases, the trustee needs to provide an annual accounting to the beneficiaries. In some cases, that requirement is waived in the trust document. So you can decide whether you want that or not. So this revocable living trust that we talk about a lot, it is an inter vivos trust. It means it's set up during your lifetime. It is revocable so long as you are alive and competent. It is administered and distributed by the trustee. Usually when we set these up, let's say it's my living trust, I am not only the grantor, but I'm also the trustee and the beneficiary until I'm no longer capable of being the trustee or the beneficiary. And then the alternate. So anything that is titled in the name of that trust is not considered in my separate name. So as you'll remember from our conversation earlier, that means it's not part of my probate estate. It does not go through my will. So anything that I have titled in the name of my living trust, let's say when I die, it will pass according to the trust terms, regardless of what I have in my will. My will have absolutely no control over anything that's titled in the name of my trust. None. Even if I say it does, it doesn't. So here are some of the, what we usually see. The grantor, as long as they're alive and competent, retains control. So let's say I'm the grantor of my own trust. I can amend that trust if I want to. I can take assets out of it. I can put assets in it. I can change the beneficiaries. I can change the trustee. I can do anything I want as long as I'm alive and competent. Generally, I do not need a separate tax ID number because it is ignored for income tax purposes. So the IRS doesn't give a hoot about my revocable living trust. They're going to treat it like me. So everything just goes on my 1040. Now, if I want a separate ID for banking purposes or something else, I can get one, but usually it's just reported straight on your 1040, and we don't get a separate tax ID number unless the trustee or the grantor becomes incompetent and we have another trustee, then we usually get the tax ID number. Okay, this is what I was just talking about. The grantor trust, all the items of income and deductions are reported on your personal 1040. The good news is that your personal residence qualifies for that section 121 because that trust is ignored for income tax purposes. You don't pay rent while you're living in your house owned by your trust. Again, you must fund the trust to avoid probate. We just talked about that. This last bullet point is important because when you have a revocable living trust, it technically takes the place of a will in terms of its dispositive provisions, who gets what and how, but we still want to have a backup will. We call it a pour will, because remember that revocable living trust is only going to govern the assets you title in that trust. Many people set up a trust. They may or may not transfer everything into it, but let's say they do. They do a great job. They get everything in it, but 20 years down the road, they buy a pickup truck and they forgot to title it in the name of their trust. That pickup truck have to go through probate if it's in their separate name, meaning it would go through the will. So we have this backup will that's called a pour over will, because what it says is anything that goes through probate, pour it over into my trust to be administered according to the terms of the trust. So that pickup truck would still go through probate, but it would just go to the trust, and the trust have provisions in it about who gets what and how. So we do not have to repeat those in our will. So that pour over will is a very, very important point or part when we do a revocable living trust. Okay, this first bullet point is incredibly important. A revocable living trust does not provide you any creditor protection, no actual protection. This is also true, by the way, for the land trust or the title holding trust you guys have heard about, may have heard about. That is a form of revocable trust. It's slightly different than this one, but a lot of people believe that those land trusts provide creditor protection, and they do not. There's absolutely no state creditor protection in the land trust or title holding trust or personal property trust. It may provide a smokescreen and anonymity, but please don't think it provides you creditor protection. General rules: if you can control something like you can in these revocable trusts, your creditors can get to it. All right, why do I like a revocable living trust over a will alone? Now remember, we still want a will. We want to pour over a will if we have this revocable living trust. But I like that trust with a will plan better than a simple will, because I can use the revocable trust as disability planning. If everything is owned in that trust and I'm the initial trustee, but if I become disabled, my alternate trustee again, we don't have to change the title or anything on the bank accounts or anything else. That trustee will step right into my shoes as the trustee. If I have real property in more than one state, now I'm actually going to avoid probate in all of the states in which I own real property, because real property must be probated in the state in which it's located if it's not in an LLC. We'll talk about that in a second, or a corporation, and probably don't want real estate in a corporation. Anyway, so if right now I have real estate in Virginia, North Carolina, Kentucky, and New York. Okay. If I died and those were all in my separate name, those properties would be probated in those 4 states. That's 4 probate proceedings that would have to be opened. It would be awful. Instead, I could title all those pieces of property in my trust, and it will avoid probate in all those states. The other thing I could do, which I've done for many of these, is I can put them in an LLC, limited liability company, which is considered personal property. Personal property is probated in the state in which you're a resident when you die. So now what I'm probating is not the real property itself. I'm probating the LLC interests, which just happen to own the real property. But if you have real property that's just in your separate name, not in an LLC and not in a trust, if through probate in the state in which it's located. So if you're in multiple states, a trust will help you avoid multiple probates. And we can do a lot of estate tax planning and some income tax planning with either revocable trusts or wills. It's pretty much the same tax planning. So if you decide to use a revocable living trust, we talked about it's better to go ahead and fund it during your lifetime so that things don't go through probate. Anybody can use a revocable living trust, but sometimes if you have a truly simple estate and you're living in a state where probate is very simple, you might not need to go through the cost and expense and headache of a revocable living trust yet, but just realize it's not like there's somebody can do these things. As we mentioned earlier, it can be a beneficiary of your retirement plans, but you only want to do that if you really need the trust. It's not a DIY thing. Talk to an advisor who's familiar with retirement beneficiary things, beneficiary planning. And we talked about the ease of transition to assess if you can't do it anymore. I want to mention briefly irrevocable trusts. We're not going to have time to go through them, but I wanted to mention them to you. So an irrevocable trust can be used like a revocable trust for probate avoidance, but we use it a lot for asset protection, and we use it a lot to reduce the value of your estate. So it's not subject to maybe at death. We might use it to manage assets for a disabled beneficiary. You can establish an irrevocable trust during your life or have it created upon your death through your estate planning documents. Once you set this up, though, whether it's during life or at death, it is irrevocable, unchangeable, unamendable, unless a court order allowing for it. And there are cases where we can get a judge to agree to let us amend an irrevocable trust, but it's a lawsuit and it's expensive. So you don't want to count on that. Usually when you set these up for asset protection or to get things out of your estate for estate tax purposes, you, the grantor, are not going to be the trustee, and you're not going to be a beneficiary, with a few exceptions. There are, I think, 12 or 14 states now that allow you to have what we call a self-settled domestic asset protection trust. That is an irrevocable trust you set up yourself, with your assets under the laws of that particular state. And you need a lawyer to do this stuff. If you set it up under the laws of these particular, I think it's 14 states, then you may possibly be a permissible beneficiary. You can't demand any money back, but you can hold your hands out and ask the trustee for a distribution, and they can say yes or no. So there are those potential exceptions we can get somebody back, but you're not going to be the trustee. You're not going to be able to change the beneficiaries and things like that. And those trusts, by the way, have their own tax ID number. They file a tax return, and the income is either income tax is either paid by the trust if the income is accumulated in that trust, or paid by the beneficiary if it's distributed out to the beneficiary. And if that is the case, the beneficiary gets a K-1 reporting that income that they then report on their personal tax returns. Okay. I want to move in. I know we're almost at 9 o'clock. I'm not sure how long I'm supposed to go because we got started a little bit late, but I want to talk about the estate taxes because we've got a big issue coming up in less than 2 years about the amount you can pass tax-free dropping drastically. So let's go through this briefly, then we'll probably stop and take questions. So the federal government assesses a tax on the transfer of wealth. So they assess it potentially when you give assets away during life, and they assess it when you transfer assets at death. The good news is not every transfer will result in an actual tax being paid, because there are a lot of credits, deductions, and exclusions that we can use to greatly reduce those transfer taxes. So let's talk about what those are. Oh, by the way, we've got this third tax: state tax, gift tax, generation skipping transfer tax. If you try to give assets directly to, say, your grandchildren or more remote descendants, or to someone who's more than 2 generations younger than you. I think they have that at 37.5 years. And, oh, by the way, the maximum estate tax rate is 40%. 40%, it's a very high tax. Used to be up to 55. Okay, here are our estate tax credits, deductions, and exclusions. If you are married to a U.S. citizen spouse, you can leave an unlimited amount of assets to your spouse during life or at death. Unlimited. If you are married to a non-U.S. citizen, you can currently gift them $185,000 per year under a marital deduction. You can get a marital deductions for assets that you leave to a non-U.S. spouse at death or during life. More than that, but you have to do it through a certain type of trust called a qualified domestic trust, and it's a pain in the rear end. And you'd have to talk to a lawyer about doing that. It is not something you do with LegalZoom. There's also an unlimited charitable deduction. You could give during life or leave at death an unlimited amount to charity and not be subject to gift or estate tax. Now, that is different than income taxes, where your deduction for income taxes can be limited based on your income. But for gift and estate tax purposes, we have unlimited deduction if you give stuff to qualified charity. We also have this big thing called the Unified Credit Against Gift and Estate Taxes. What the heck is that? That is a credit against your taxes that basically says that during your lifetime or at death or some combination thereof, you can give away $13,610,000 right now. So if somebody had that amount they wanted to give to me, you could stroke me a check for 13 million plus, and it would not be subject to gift taxes. Now, that is a unified credit. So if you use part of it during your lifetime, you have less to use at death. So let's say that I gave somebody $10 million under this credit. I would only have $3,610,000 left to give at death, free of estate taxes. The second bullet point on the small list is the important one. on January 1st, 2026, really after December 31st, that amount that's now over 13 million is dropping to $5 adjusted for inflation. What does that mean, adjusted for inflation? They'll tell us at the time what that number is at the time of death, but right now they're estimating that is about $7 million that you will be able to leave during life or at death after 2025, as opposed to over 13 million. Huge cut. That's almost in half. It's almost in half. How easy is it for you real estate investors to quickly get up to $5 million or even $7 million? You know, some apartment buildings, a large rental portfolio, a large primary home, some stocks. There are going to be a lot of people caught with taxes in that 40% bracket that they died before 2026. So we want to make sure that you're setting yourself up to plan for that. And so I highly recommend that you, if you're in that situation, you have an estate of more than 5 million, or you and a spouse together have 10 million or more, that you talk to an estate planning meeting about how to deal with this. And I'm going to give you a few examples, but it's really something, again, another not a DIY. You want to make sure you talk to a qualified estate planning attorney who knows what they're talking about. The first thing we want to do is we want to realize that that 13 million, 5 million, whichever it is, I'm going to call it 5 million examples because I'm going to assume you're all going to live to 2026. That's not that far away. And I'm going to call it 5 million because we don't know what it's going to be for inflation. Like I said, it'll probably be 6, 7, but let's just call it 5. Each person in a married couple has that $5 million exemption in 2026. So the husband has it and the wife has it. We want to make sure that plan that each of those spouses gets to use their 5 million credit, or right now 13 million, whatever it is. There's something we now have called portability. If I die and I leave everything to my spouse, let's say I had $10 million. If I die and I leave $10 million to my spouse, he gets it free of estate taxes because of the unlimited marital deduction. I could leave him 10 billion because he's a US citizen spouse, but I leave him my 10 million. There's no tax owed because of my marital deduction. But I did not use my unified credit, my applicable credit, it's another name for it. So I just wasted my 5 million or 10 million, whatever, let's say it's after 2026. So I wasted my 5 million index for inflation because I didn't use my credit. However, my husband, if he's on the ball, would file an estate tax return for me, even though no taxes are due, would file an estate tax return and check a box that preserves his right to use my credit and his credit. He has his credit either way, but if he wants to go back and snatch my credit that I didn't use, he's got to file a gift tax return 9 months after the date of my death, checking a box to preserve that right. Okay, that's very, very important. So the first thing we want to do is make sure that each spouse is going to be able to use their credit. You can do portability, but that requires the surviving spouse to file that tax return, even though no estate taxes are due. And we'll get to, if we have time, some other things we can do with trust, but that is very, very critical. And if you have your estate plan or you have a file for your estate planning, I would tell you, let me go back to that slide. I would tell you to put a note in big, black, ugly print, reminding your surviving spouse to contact an estate planning advisor after your death about the advisability of filing that estate tax return to preserve that right to use the deceased person's credit. Put a big, ugly note in your file so the spouse sees it, but won't remember this. It's not top of mind for us. Okay. The other thing that we have is called an annual gift tax exclusion. So we can give away this year up to $18,000 per person per donee. So if I had 10 grandchildren, I wanted to give each of them 18,000, I could do that. Just write them a check, give them cash, give them a slice of real estate valued at that, whatever it is. And I don't even have to file a gift tax return if I do that. Okay. I can also, if I'm gifting that money through a 529 plan, I can actually upfront 5 years worth of that $18,000 a year in 1 year. Usually it's $18,000 per calendar year, but in that particular education plan, that 529 plan, I can put 5 years in at once. So if I had grandchildren and I were nearing the end of my life and I was worried I wouldn't be alive for 5 years to make those gifts, I might choose to set it all up and put 5 years in a 529 in 1 year, if that makes sense. So we also have a generation skipping transfer tax exemption. Remember, I told you this is the tax when you leave things to your grandchildren or people who are more than 2 generations younger than you. That is the same amount as the estate tax exemption, but it is not portable between spouses. So if the first spouse dies, too bad, so sad. The second spouse cannot go back and capture it. We can also gift free of estate and gift taxes, gifts for medical and educational expenses. There's a certain list in the tax code, but you have to pay it directly to the vendor. So directly to the college, directly to the doctor. You can't reimburse someone if they put it on their credit card, things like that. You have to pay it directly to the institution or the medical facility or whatever it is. Okay, when we're determining whether or not you have a gross estate that will result in federal estate taxes, we have to calculate what that gross estate value is. Remember, I told you that was the big circle that includes every single thing you have an ownership interest in, regardless of how much you own. So we're going to list all of our assets and we're going to determine the fair market value. There's the definition right there. You guys are real estate people, you know what that is. And don't forget to include everything. You have some Hummel figurines sitting on your bookshelf. Those are valuable. You have a nice piece of artwork on your wall. That's valuable. Antique rug. That's valuable. Cash in your safe. Valuable. All of those things, everything, every single thing has to be added up. And for any personal property like the Hummel figurines or basket collection or anything else, the value you have to put down is not what you get it sold for at a garage sale. It's the retail value that someone would sell it at a retail gallery. So think about that. And I'll never forget when I prepared my very first estate tax return. I was a 28-year-old lawyer, first year out of law school. And we had to, I'm trying to think what I was going to say. We had to put down everything. And reading the estate auditor handbook to try to get, my head around the IRS. And they had practitioner tips for their IRS auditors. And one of them said, ask the ambulance driver if the deceased person had money in their pockets. Literally, that was a practitioner's tip that the IRS gave the estate tax auditor. It was just terrible. They're serious about this, serious. Okay, so what's included in that giant circle? 100% of the fair market value of anything that's in your separate name, 100% of something you own jointly with someone other than your spouse, unless you can prove what they contributed. So if Anna and I owned a property jointly and I died first, 100% of the value of that property would be included in my list of assets, unless I could prove what Anna contributed. Think about that. So keep good records. 50% of the assets you own jointly with your spouse is included in your list. 100% of anything in your separate revocable, 50% if you own that jointly with your spouse. 100% of your life insurance death benefit if you have any incident of ownership in that policy. So if you own the policy, or if you can change the beneficiary of the policy, things like that, then 100% of the death benefit is included in your list, not the cash value, but the death. This trips people up because we've always been told that life insurance is not taxable. And that is true as far as income taxes go. It is not true for estate taxes. So keep that in mind. And we talked about the retail prices on the personal property, but of course, anything 100% in your IRA, 401k, that's also included. These are states currently. So you can see that we jump up to that 40% pretty darn quickly. You can take a picture of that if you want to. If not, I'm happy to make these slides available to the RIA if they want to hand them out to you guys, by the way. Okay, so how do we avoid or minimize estate? We're going to have over that $5 million index for inflation in 2026. And we want to start planning. What can we do? Well, we can start giving money away, right? We can reduce the number of assets in our estate. We can reduce that by using that $18,000 a year outright to anyone. This bullet about being in trust, let me explain. When you're trying to qualify for that $18,000 a year annual gift tax exclusion, it only counts when you make a gift of a present interest. So if I gave you $18,000 cash or a check, you could presently use it, possess it, enjoy it, whatever you want to do with it. But if I put $18,000 in a trust, you bet until I die, that's not a present interest, that's a future interest. So if we want money in an irrevocable trust, what we have to do is add a paragraph. It's called these Crummy powers. I know it's a funny name, but it was named after Mr. Crummy, who fought the IRS on this issue. And basically those powers say that paragraph says, when money is contributed to the trust, the beneficiary has to get notice of that and has 30 days to take it out. The number of days can change, but that's what most people use. You have 30 days to take it out, no strings attached. But if they don't take it out, then it stays in trust until whatever the trust terms say when they get it later in the future. That makes it a present interest, turns it from a future interest into a present interest, and allows it to qualify for that $18,000 a year exclusion. So we can do the $18,000 a year. We can pay people's medical or education expenses directly to the vendor. We can make gifts to charity, either outright or in trust or in a donor advised fund. We're trying to get rid of assets in our state. So we can reduce our estate, but of course we're giving assets away, so we don't have them anymore either. So keep that in mind. That's probably fairly obvious. If we want to go ahead and use up part of that $13,610,000 exemption amount that we have, we can use part of that credit during our lifetime. Let's say that I wanted to go ahead and up my estate down to 10 million, 5 million for me, maybe 5 million for my spouse. We could go ahead and gift away the excess amount, use our credit now, and when it drops in 2026, we're going to be okay. They've already said they're not going to go back and claw that back just because it dropped between the time you made the gift and the time. So you can go ahead and use part of your lifetime credit, file a gift tax return to use it. You can put assets in that, say, an irrevocable trust or outright. And not only are you getting the asset out of your estate at its current value, but any appreciation will now be on the ledger of whoever you gave it to and will not be subject to estate tax when you die. You already gave it away. So you can do that. But remember, when you're giving things away, you no longer have the right to use it yourself or control it. You can, if you have, let's say you have a big insurance policy that is going to be added up in your estate and subject to estate taxes, you can put that in an irrevocable life insurance trust. And if you put an existing policy in a trust like that, you will have to live 3 years. But if you survive 3 more years, then when you die, the value of that death benefit is not included in your estate. If you set up the trust first and you have the trust buy a brand new policy, there is no 3-year rule. You could die the next day. It's not taxable in your state. You can make gifts to the trust of the premium amounts using that $18,000 a year exclusion if it's set up correctly. Okay, so that is one thing we see a lot. This is an interesting one. So we've talked about, we want to make sure that both spouses use their tax credit through portability. We want to give away some assets if we need to reduce our estate. But what if we don't want to give away assets, but somehow we want to reduce the value? We want to squish that value so it looks like less in the eyes of the IRS when you die. We can use LLCs or family limited partnerships to possibly obtain these valuation discounts. And let me explain what I mean by that. If I had $1 million piece of property outright in my name and everybody agreed that that was the fair market value, $1 million, and I came to Anna, I keep picking on Anna, but I say, Anna, I've got this $1 million piece of property free and clear in my name. Would you buy 90% of that for $900,000? 90% of $1 million is $900,000. Would you give me $900,000? And you'd get that 90%. You could do with it what you wish. She would probably say, yeah, that'd be great. But if I put that $1 million property in an LLC or family limited partnership, and I made myself the manager, and I said, she can't manage it. She can't sell it without my permission. She can't do anything without my permission. Do you think she'd pay me 90% of the value then? I doubt it, because it's not worth 90% to her anymore because she's just a passive investor now. So we can squish the value by all these discounts. That LLC interest is not as marketable as the outright real estate. She doesn't have any control. Maybe she's a minority interest holder, or maybe it's a future interest. I've put it in a trust or whatever. So there are various ways that we can get an appraisal. It does take a business appraisal. And we can say, dear IRS, that property is no longer worth $1 million. It's worth only $550,000 if I get a 45% discount. Or it's worth, gosh, much less if it's, say, an 85% discount. We never see it that high, by the way. It's usually 10 to 45%, sometimes as high as 50. But do you see how that can be really valuable? Or if we say this $1 million property is going to be split up between 5 different irrevocable trusts, each one owning 200,000, all the trustees, nobody can make a decision without all the others. You see how it makes it less valuable? So there are ways to get legitimate discounts, but it's an involved plan. So you do need an attorney, and it will require appraisals, business appraisals, not just property appraisals. All right, we talked about making sure each spouse's credit is used. I'm not going to go through these 2 types of trusts, but there are ways that we can set it up. So rather than the spouse having to remember to check the box on that estate tax return, certain trusts can potentially be used to make things more automatic, to use both credits. And we don't have time to go through all of this, but that's if anybody wants it. Charities, we can make gifts to charities. So I'm going to stop now because I want to make sure we have time for questions, and it's already after 9. So basically, in conclusion, this may seem tedious, scary, overwhelming. Don't let it stop you. It's the nicest gift you could give your loved ones, to take care of this. Do your estate planning documents, write your ultimate love letter workbook where you put all of the information in for your beneficiaries and your loved ones so they know what to do to administer your estate. Don't procrastinate. You can always tweak it later. This is your ultimate love letter. Do not procrastinate. And if you need codes, when I finish my ultimate love letter, by the way, I'm going to turn this into a very pretty little template. Somebody's got to help me make it pretty. And it'll be in digital format. If anybody wants to be notified when I have that template ready, it will be for sale at some point. Scan that QR code. You just go on an email list, and I'll just let you know when I get it done in case you have any interest. And if you need to get in touch with me, the QR code with my name on it will take you to my website. And I think it takes you to a place where you can give me your email information and get my email and phone number if you want to connect with me or have any questions that we don't answer on here. So I'm going to stop this share now and see if anybody has questions, because I know that was a lot of information in a very short period of time. Is anybody there? I hope somebody's still there. Hello? Can you guys hear me? I'm not hearing or seeing anybody.
Can you hear me?
Oh, now I can. I can hear
You can
somebody.
hear me? So we have,
Yeah.
Can you hear me now?
okay, how about there?
I hear somebody.
Okay.
There you go. Now I can see you. So I know that was fast. It was a lot of information. Oh, thank you guys. So I am here as long as you need me to take questions.
Yeah, we have a
Okay,
question.
Mary, you had
Mhm.
mentioned the importance of tightening everything into the name of the trust. But then you also talked about a pour-over will that would accomplish the same thing. So wouldn't it just be easier to create the pour-over will than taking the time and effort to assure that everything is titled in the name of the trust?
No, because what happens with the pour will, you still have to go through probate. So it ultimately gets to the trust, but if you don't title it in the name of the trust, then all those assets, if they're in your separate name, have to go through probate before they get to the trust. So it's being tied up for a couple of years and a lot of money and headache. If you put it in the trust, it just can be administered very quickly.
Thank you. Thank you.
So the pour of a will is your in case you forget something, but it's not it's not the way you want to do it.
Okay, we have another question coming up.
Okay?
One more here.
All right, so if you have a bunch of LLCs that own property, now you said the LLCs for personal property.
Yep.
And to make sure those LLCs put into your living trust because they're owning all this property. How would you do that?
Yeah, so it's hard for me to hear, but what I think you said, you own a bunch of LLCs, which are considered personal property, but you don't necessarily want to probate those LLCs either. So how do you get them in your living trust? Your living trust becomes the member, who is the trustee of your living trust, become the member of those LLCs. So for me, when I set up my LLCs, Mary Hart, was the member. But once I set up my estate planning trust, I assigned my membership interests from me individually to me as the trustee of my revocable living trust. Just a standard assignment like you would assign any contract, but I'm assigning my LLC membership interest. That puts it in the trust.
Okay, so follow up to that. Do you do that as soon as you have the LLC in the living trust all ready to go, or do you just do it road? Okay.
No, I do it. I mean, ideally, I would have set up first. So when I set up my LLCs, I just would have made the trust the member right away. But I had my LLCs before I did my trust, which most people do. So then I just assigned my interests from me individually to me as the trustee of my trust. And then I revised my operating agreement. So now I don't sign it as a member individually. I sign Mary Hart, trustee of the Mary Hart Trust, or whatever it is. So I make it clear that that membership has changed from me individually to me as the trustee.
So for the future, like you're buying new properties or whatever, you're now signing as trustee of the John Doe Trust.
Well, for the LLC, if you're signing, if the LLC properties, you're signing as the owner of the LLC. But yes, if you're signing, it would read like 123 Main Street LLC by Mary Hart as trustee of the Mary Hart Trust, comma, member manager.
Got it, thank you.
Mhm.
What sort of maintenance costs could one expect? Annual maintenance costs?
For a
Especially
trust,
a bank as a trustee.
it's really hard to hear. Can somebody repeat that louder?
What would the annual maintenance cost be typically to establish?
Annual maintenance costs for the trust?
To establish a trust, yes.
Yeah, there shouldn't be any annual maintenance costs. It's just a private document. It's not recorded or anything. And so the only cost would be if you needed to, transfer something else into it and needed to draft a deed or something like that. Remember that it's reported as just your regular 1040 on your income. So it does not have its own income tax return or anything like that either. So there should not be really any ongoing maintenance costs of a revocable living trust.
Hi, Mary.
Hello.
The 3-ring binder, it's got all the information in it, and they talk about having your passwords, your bank account numbers and all that. I've heard some people give it to each child, but locked in a lockbox, and their child has the key. I mean, you don't want that around. That's everything about you.
Yeah, no. You definitely don't want it around. So here's what I plan to do. I'm personally gonna have a 3-ring binder, and I'm gonna have it in digital folders on a thumb drive. My thumb drive is gonna be in my safety deposit box, and I have named my oldest child as a co-signer on that safety deposit box, because he's the one that's gonna press and all that. And so he will have the binder. I'm not giving it to everybody, just to him and my husband. He will have the binder, and he'll have the ability to get the thumb drive that has all the digital copies too. So he'll have all the original documents and the digital copy from my safety deposit box. Does that make sense?
Makes sense? Yes, she's nodding yes.
One more?
Okay.
Yes, it makes sense, but still, you're saying put all of your passwords and account numbers in that binder? put it in a fireproof box, but if somebody breaks in and takes your fireproof box, they've got everything.
Yeah, I mean, you have to do what you think is safe. For me, we have a giant safe, a real safe, not just a fireproof box, a real safe. So my husband and my son will have the combination to my safe, which is where the binder will be. The thumb drive will be in a safety deposit box, and I might put a duplicate in the safe. Nobody else will have that. I mean, that's how I'm going to do it. You'll have to figure out what you think is a safe place to put it. And there's always a balance between not having anything available because you're worried somebody's going to break in and steal it, but then not having anything available for the people who need the information. So you've got to find that balance. I was going to say something else about that too. I don't remember what I was going to say, but yeah, I'm not going to have I know what I was going to say. I also have a password app on my phone and my computer and all that. So in the binder, I'm just putting in the master password to my password app, and then they'll have to, into my phone, and then they'll have to get into that app. I'm not going to repeat 1,000 passwords because then I'll have to change them every time I change a password. I'm just going to give them the master password, but that will all be in the safe or the safety deposit box. And the two people in charge will know how to get in there.
I have a question about a revocable living trust. I have that, but how do I make sure that I protect whoever I'm giving the money to, that I don't affect their VA benefits, their, whatever, send them into a huge tax bracket change? How do I do that when I'm not a reader? Hopefully.
Well, that's all in how you set up the estate plan. And that's why I say it's generally not a do-it-yourself thing, because if you have beneficiaries who qualify for like Social Security disability or other things like that, you might want to leave it in a way that, create your estate plan so that any assets going to that, let's say it's a disabled child, go into a certain type of trust. It's called a supplemental needs trust or special needs trust. It is specifically designed as a way to leave assets to, say, a disabled person who qualifies for government benefits in a way that does not qualify them for those benefits, but leaves an extra fund of money that a trustee can use for their benefit, for things that maybe those government benefits don't pay for, like a trip to Disney World with the cousins, the chair that pushes you up, or certain things that, say Medicaid or Social Security disability won't pay for, but we have this like sinking fund almost over here in a trust, a little extra fund of money that is set up in a way that's specifically designed to provide those funds for that child or person within a way that does not disqualify them from those government benefits. So, but you need a good, disability estate planning lawyer who can set that up for you.
Thank you.
You're welcome.
Another one.
Thank you for that. I do have a question. You did multiple bullet points of different benefits of different trusts, everything from disability and taxes and all the estate plans and that. Is it possible to do all that in one? If you got a bunch of different, say you got like my fiance and I are both looking to be on the trajectory to be meeting them $5 million limits before too long, stuff like that. So we're really looking into tax stuff, and that as it is now. We both have minor children that we're bringing in, so it'll be a blended family situation. Can you use one trust, say once we're married, to cover all those bases, or do you need to set up different types of trusts?
So a classic lawyer answer again, it depends on really what you want and what your circumstances are exactly. But a lot of times with married couples, we will use a joint trust that then splits into different types of subtrusts when one or both spouses are deceased. In some cases, we will do one trust for each spouse. Like if they have different ultimate beneficiaries and things like that, we might use a separate revocable living trust so they each manage their own asset during life. Then at death, we set it up maybe so it goes into trust for the spouse during his or her life. But then when that spouse dies, it goes as the first person has said it goes. Like I use that example with my husband, where, maybe I do have my very own revocable trust that I had before I met him. And so my assets will go, whatever I can leave free of taxes, I might leave to my kids, and then the rest in a trust for my spouse that will support him during his lifetime. But when he dies, it will go to my kids, and he can't change that, for instance. So there are a number of different ways you can do it, and that's why you need to talk with an estate planning attorney about exactly what your situation is and what your goals are.
Mary,
Yeah,
you're
you're
so
welcome.
good and you're so knowledgeable, but how are we going to know that we can get the same thing done here in Ohio? Is there a way that we can stay connected with you?
So there are a couple of, first of all, I'm not drafting documents, and I'm not licensed in Ohio, so I can't be your lawyer.
What?
Oh, I'm sorry, I heard something. But anyway, but whoever's moving the camera, I'm getting really dizzy. Anyway, you could go to that lawyers.com and look for estate planning lawyers in your area, and look for a firm that represents, high net worth individuals. If that's what you are, look, and call 2 or 3 firms and get a sense of whether you think they know what they're talking about, and if they have clients like you, for whatever your situation is. If you need me, the reason I do consulting, I don't even really market it, but I have found a lot of lawyers don't understand the special needs of real estate investors. Like, they don't know what land trusts are. They don't know what self-directed IRAs are. They don't understand wrap loans or subject to or all that kind of stuff. So where I get called in a lot of times is if it's a more complex situation and the real estate investor wants to meet with me to sort of point out a plan, all the real estate investments, and then we give the memo to the lawyer, says draft it like this. Or if I have to liaison with the lawyer to explain a specific thing, like, well, this is what a self-directed IRA is, and this is what a land trust is, or whatever. So
tell us about your monthly meetings.
I'm sorry, say that again.
Tell us about your monthlies.
Yeah, you have a
monthly meeting?
monthly meeting.
Oh, I do have a monthly membership. I don't know how long it will keep going, to be completely honest with you. It's $149 a month. We have 2 Zoom calls a month for an hour and a half each call. It's the first and third Thursdays of the month at noon, but everything is recorded, and everybody in that gets a free 30-minute consultation with me every month if they want it. It's called the AIM Hire Academy. On that QR code I showed you, that will take you to, I think, a link to that website if anybody wanted to sign up. It is just month by month because I'm not sure whether I'll keep it going forever. I've had it for a couple of years, 2.5 years or something, and it may go forever, it may not. I'm trying to make that decision right now. What else can I answer? Can you please share that QR code? Yeah, let me share my screen again real quick. Let's see if I can pull this up. Hold on just a minute. There you go. There's the QR code. Can you guys see that? The one that says Mary Hart in the middle of it is the one that will connect you with my email and phone number and the website for that membership. It's called the AIM Hire Academy. All right. Did everybody get that? Can I stop sharing now so I can see you guys? Okay, I'm gonna stop, and I can always pull it back up if I need to.
If an estate planning attorney offers to be one of the trustees, is that a red flag?
For me, it is. For me, it is. I don't like that myself because I feel like, and I've seen it many times, 30 years of lawyering, I feel like it's a way that people just insinuate themselves in for future business.
Yeah.
And I would rather have an alternate trustee that, if I don't want to use a family member, that is a trust company that is specifically set up to serve as trustee and is not the lawyer who drafted the documents. They do it all the time. I just don't believe
What kind of company would that be as a trustee?
so. There are trust companies. If you Google, estate planning trust company, or I'm trying to think, there's like one called Northern Trust in Arizona, for instance. There are a bunch of them. I don't know all the names of them, but it's a trust job is to serve as trustees for people. You can usually find them sometimes associated with a wealth advisory firm. They might have a trust and estate planning arm that will serve as trustees. Does that make sense?
Personally, they don't need to be lawyers,
No, 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 you don't have to be lawyers.
even in the same state. Not even in the
They
same.
don't necessarily have to be in the same state as long as they have, if it's a trust company, they have to have a charter that allows them to be a trustee in that state. But many of them are nationwide.
What would they charge?
It varies usually depending on the value of the assets under management, you know, anywhere from 0.25% to 1% or so, depending on how much they're managing per year.
You've been fantastic.
Thank you. Thank you. I know it's a lot of information. Anyway,
So much, and I'm glad that
you're
you,
quite, are you done with me?
yeah, I'm glad you talked me into the Zoom. We wanted you bad enough to do that, so it's wonderful.
Yeah. Sorry, it's just really hard to hear. There's an echo in the room or something. It's hard to hear you.
Hey, guys, how about a round of applause for our
Thank you. Thank you guys for listening. I know it's a very dry subject. Thank you for listening, and thank you for inviting me, Anna. And I'm going to sign off now unless you need me for anything else. No?
We're good, thank you very much.
Okay.